Welcome to the second part of our video series on this topic. In the first part, we discussed Section 204 of the Companies Act 2013, its rules, and the template form number MR3. Our goal is to understand these provisions in practical terms, avoiding excessive theoretical discussion. We will approach this through a question and answer format and provide examples to help you grasp the concepts. This way, you will be equipped to execute your responsibilities as a company secretary and compliance officer effectively. Before we delve into Regulation 24A of SEBI LODR, let's clarify two important concepts. First, a subsidiary company, as defined under Section 2, subsection 87 of the Companies Act 2013. Next, we have the term material subsidiary, defined in Regulation 16, Sub-Regulation 1, Clause C of SEBI LODR 2015 as amended thereto. Question 1. What do you mean by subsidiary company? Answer. Pursuant to Section 2, subsection 87 of Companies Act 2013, a subsidiary company is a company in relation to another company called the holding company if that holding company exercises control in any of the following ways. A. Control over composition of board. The holding company controls the composition of the board of directors of the subsidiary company. Control means the holding company has the power to appoint or remove all or a majority of the directors. Or B. Control over voting power. The holding company exercises or controls more than 50% of the total voting power either on its own or together with one or more of its subsidiary companies. Conclusion. A company is considered a subsidiary if another company has significant control over its management or voting rights. Example 1. Shareholding control. Company Suffer or Seek Limited holds 60% shares in Company Seek Limited. Since Company Suffer or Seek Limited has more than 50% voting power, Company Seek Limited is a subsidiary of Company Suffer or Seek Limited. Example 2. Board control. Company Suffer or Seek Limited holds only 40% shares in Company Seek Limited. But Company Suffer or Seek Limited has the right to appoint 4 out of 6 directors. Even without majority shares, Company Suffer or Seek Limited controls the board. Company Seek Limited is a subsidiary of Company Suffer or Seek Limited. Example 3. Indirect subsidiary. Company Suffer or Seek Limited holds 60% in Company Seek Limited. Company Seek Limited holds 60% in Company Knowledge Limited. Even though Company Suffer or Seek Limited does not directly hold shares in Company Knowledge Limited. Company Knowledge Limited is also a subsidiary of Company Suffer or Seek Limited, indirect subsidiary. Quick summary. A company becomes a subsidiary of another company, controls more than 50% voting power or controls the composition of board of directors. Question 2. What is a material subsidiary? What are its compliance requirements? Answer. As per Regulation 16, Sub-Regulation 1, Clause C of the SEBI LODR Regulations 2015, a material subsidiary is a subsidiary whose income greater equal to 10% of the consolidated income of the listed entity or net worth greater equal to 10% of the consolidated net worth of the listed entity. This is calculated based on the immediately preceding accounting year. Examples 1. Based on income. For FY 2025-2026, based on FY 2024-2025 data, listed company, Suffer or Seek Limited. consolidated income 1000 crore rupees. Subsidiary Seek Private Limited, income 120 crore rupees. Calculation 120 divided by 1000% equal to 12%. Since 12% greater than 10%, Seek Private Limited is a material subsidiary. Example 2. Based on net worth. Listed company, Suffer or Seek Limited, consolidated net worth 500 crore rupees. Subsidiary, Seek Private Limited, net worth 60 crore rupees. Calculation, 60 divided by 500% equal to 12%. Since 12% greater than 10%, it is a material subsidiary. Example 3. Not a material subsidiary. Consolidated income 1000 crore rupees. Subsidiary income 50 crore rupees. Calculation 50 by 1000, 10%. Not a material subsidiary. Question 3. Whether corporate governance applicable to material subsidiary unlisted company? Yes. Pursuant to Regulation 15, Sub-Regulation 2 and Sub-Regulation 3 of SEBI, Regulations 2015, Regulation 15, Sub-Regulation 2 specifies applicability of corporate governance provisions, Regulations 17 to 27, etc., primarily to listed entities based on criteria like paid-up capital or net worth. Regulation 15, Sub-Regulation 3, the provisions of Regulations 17 to 27 and clauses B to I of Sub-Regulation 2 of Regulation 46 shall apply to a listed entity and shall also apply to the board of directors of the unlisted subsidiaries to the extent specified in Regulation 24. Quick summary. Even if a subsidiary is unlisted, certain corporate governance provisions still apply to it indirectly through Regulation 24, Corporate Governance Requirements for Subsidiaries. What does this practically mean? The following corporate governance provision extend to unlisted subsidiaries. Examples: Appointment of Independent Director, Regulation 24(1). Review by Audit Committee, Regulation 24(2). Placing minutes before listed company board, Regulation 24(3). Restrictions on disposal of shares, Regulation 24(5). Disposal of assets, Regulation 24(6). Example: Suffer or Seek Limited, listed company, has Suffer Private Limited, unlisted subsidiary. Even though Suffer Private Limited is unlisted, it must still comply with governance oversight by Suffer or Seek Limited, audit committee review, board level monitoring, restrictions on major transactions. Structure: Suffer or Seek Limited has 3 subsidiaries for the FY 2025-2026, FY 2024-2025. Subsidiary income crypt percentage of total material: Suffer Private Limited 150, 15% yes. Seek Private Limited 90, 9% no. Knowledge Private Limited 110, 11% yes. Result: Suffer Private Limited, Secretarial Audit required. Seek Private Limited, Secretarial Audit required. Knowledge Private Limited, not required. Question number 4. If a subsidiary was material in year 1, but in year 2 it no longer meets the 10% criteria, does it still need to comply with Regulation 24A, Secretarial Audit? Answer: No. It is not required to comply once it is no longer a material subsidiary. Compliance under Regulation 24A applies only for the year in which the subsidiary qualifies as material. Important practical point. The status of material subsidiary is checked every financial year. If it falls below 10%, it ceases to be material from that year onward. Therefore, secretarial audit under Regulation 24A is not required for that year. Example 1 becomes non-material. Year 1. Subsidiary A income is equal to 15 crore rupees. Group income is equal to 100 crore rupees. 15% material subsidiary, secretarial audit required. Year 2. Subsidiary A income is equal to 8 crore rupees. Group income is equal to 120 crore rupees. 6.6% not material, no secretarial audit required under Regulation 24A. Example 2. Net worth case. Year 1. Net worth equal to 1-2%. Material. Audit required. Year 2. Net worth equal to 7%. Not material. Audit not required. One caution. Even if it becomes non-material, check board-approved policy on material subsidiaries. Ensure proper disclosure in board report or annual report. Important practical points. 1. Or condition. Even if only one condition is met, income or net worth, it becomes material. 2. Based on consolidated figures, always compare with consolidated income, consolidated net worth, not standalone. 3. Only Indian subsidiaries covered here. Regulation 24A specifically says incorporated in India. So, foreign subsidiaries not covered under this clause. 4. Timing. Materiality is checked based on last audited financial statements. Question number 4. If a subsidiary was material in year 1 but in year 2 it no longer meets the 10% criteria, does it still need to comply with Regulation 24A Secretarial Audit? Answer. No. It is not required to comply once it is no longer a material subsidiary. Compliance under Regulation 24A applies only for the year in which the subsidiary qualifies as material. Important practical point. The status of material subsidiary is checked every financial year. If it falls below 10%, it ceases to be material from that year onward. Therefore, secretarial audit under Regulation 24A is not required for that year. Example 1 becomes non-material. Year 1. Subsidiary A income is equal to 15 crore rupees or group income is equal to 100 rupees. 15% material subsidiary, secretarial audit required. Year 2. Subsidiary A income is equal to 8 crore rupees. Group income is equal to 120 crore rupees. 6.6% not material, no secretarial audit required under Reg 24A. Example 2. Net worth case. Year 1. Net worth is equal to 12%. Material. Audit required. Year 2. Net worth equal to 7%. Not material. Audit not required. One caution. Even if it becomes non-material, question number 5. Can a listed company and its material subsidiary appoint the same peer-reviewed secretarial auditor under Regulation 24A of SEBI LODR? Answer. 1. Regulatory provision. Regulation 24A-2 of SEBI LODR Regulations 2015 states, the secretarial auditor of a listed entity shall be a practicing company secretary who is independent and peer-reviewed. Material unlisted subsidiary must also get its secretarial audit conducted by a peer-reviewed practicing company secretary. 2. Independence requirement. The auditor must be independent of the entity being audited. Conflict of interest should be avoided. Appointing the same auditor for both the listed company and its subsidiary is not prohibited, provided 1. The auditor is independent for both entities. 2. There is no conflict of interest, for example, significant shareholding, directorship, or related party issues. 3. Practical considerations. In practice, many groups appoint the same auditor for efficiency if independence is ensured. The auditor must give separate reports for the listed company and the subsidiary. Audit scope and observations must be specific to each company. Example, company Suffer or Seek Limited listed and subsidiary Seek Limited material unlisted. Both appoint PCS Prasad Khopkar and Associates, who is peer-reviewed and independent. PCS Prasad Khopkar and Associates issues separate secretarial audit reports for Suffer or Seek Limited and Seek Limited. Compliant with Regulation 24A, provided independence is maintained. Key takeaway: yes, the same peer-reviewed secretarial auditor can be appointed for both a listed company and its material subsidiary. Condition: auditor must be independent for each entity and issue separate audit reports. That brings us to the end of Part 2. Thank you for watching. We hope you gained valuable insights into the concepts discussed. In Part 3, we will cover practical aspects and deeper analysis that will further strengthen your understanding Regulation 24A of SEBI, LODR 2015. So don't forget to like, share and subscribe to our channel and stay tuned for the next part.